in listen-only mode.
Good afternoon, everyone, and welcome to the first quarterly HR Law webinar of the year presented by Stringer LLP, where we touch on major developments in employment and labor law that we've seen over the last quarter. We'll dive right in, but before we do, a quick bit of how-to on how to ask a question. We will, if we have time, deal with questions at the end of today's presentation. If you do have questions that we don't answer or that come to you afterwards, please feel free to email any of the presenters. We'll be happy to get in touch with you. If you want to ask a question during the webinar, on the right-hand side of your screen, you should see a box marked questions. You can just type your question in the field box as it shows on your screen there, and we'll be able to review them at the end of the presentation. You may be unable to see the questions box, in which case it's probably just not expanded. If you see questions on the right-hand side of your screen and press the plus symbol, then it should expand and you should see the question box. And if that doesn't work, then you should be able to see the orange arrow on the right-hand side of your screen, which will in turn expand the box, which will have the questions segment there and ready to be filled by you. So without further ado, I will start by touching on an evidentiary issue that has much broader implications for employers in enacting discipline. And that's the question of what is or is not a business record, which sounds a little bit like a law school exam, but bear with me because it does have some important lessons for HR professionals in terms of making sure that your discipline stays relevant going forward. So first off, why do we care about historic records like discipline? Well, in the vast majority of cases involving progressive discipline, you're going to want to rely on discipline that has been enacted some point in the past. Right? You're going to want to be able to show an escalation of misconduct or an incorrigible problem that finally reaches the breaking point. And so it's important for progressive discipline. It's important to be able to show that you've tried to address an issue with an employee on occasions before and that they're just not responding to it, and there's no way that you can keep working in the relationship without going forward. You may also need to prove verbal agreements about various aspects of the working relationship, as well as prove the employer's response to certain types of harassment or complaints. All of these can be really important factors in employment litigation. But one of the problems when you're talking about historic events is how do you prove them? Right? If you've got something that's happened 10 years ago, it can be difficult to actually keep track of the people involved. They maybe don't have the most firm recollection in the world. They may not even be with your organization anymore. Right? We're in an era where quite frequently you see people move from organization to organization in pretty tight timelines. So you may not have anyone in the organization with the knowledge of pre-existing discipline by the time that discipline ends up being part of a case for a just cause termination some 5-10 years down the road. So why are we talking about business records in this context? Well, the answer is, in short, in most litigation venues, records have to be brought before the court by way of a witness. If you have a document or you have some sort of piece of evidence, a witness has to go up on the stand and introduce it and explain to the court what it is, and they get to be asked questions about it by both the employer's lawyer and the employee's counsel lawyer. When you don't have that witness, if you can't find someone who can identify the document, who can verify its authenticity, who can speak about what it actually contains, in court and in some cases before tribunals, you may be precluded from actually relying on those documents. So that, of course, is a big problem if you're talking about, historic discipline where there may only be one or two records of what the actual incident was and what the employer's response was. So there are certain exceptions, however, to this general rule that you need to have a live witness to introduce records. And one of the most important ones is an exception for business records. And essentially, business records are a writing or record made in the course of the usual ordinary course of a business. So the easiest way to think of this, perhaps the easiest example, is something like an inventory, which is done every week. If you were to introduce that record, chances are you'd be able to admit it as an evidence, as a business record, simply by introducing it as under this exception. And you'd be able to prove that, you had 2,700 widgets in stock on a certain day simply by showing the document. You wouldn't have to provide the actual individual who created the business record, because it's the normalcy of it, the repetitive sort of stock keeping nature of it is what makes the record inherently reliable, and why the court allows that record to be admitted without having someone there to actually introduce it. And the question of the application of business records in a wrongful dismissal case really came to a fore in a case out of Nova Scotia recently called Beck and Hillside Pine Homes. Now, this was a Nova Scotia case. It was an appeal of a director's order which found that an employee was dismissed with just cause. And that just cause was really a failure to be able to work with their coworkers. Consistently disruptive behavior, constant interpersonal conflicts, that sort of thing. One of the reasons that this was litigated was because in Nova Scotia there is a 10-year, there's just cause protection for employees with at least 10 years service. So once you reach that 10-year threshold, it's only for just cause and some other specified factors that you can terminate an employee. You can't just terminate them like in Ontario without cause by paying them reasonable notice. And so despite the fact that perhaps the employer didn't want to assert cause, they were forced to assert cause by this particular provision. And so they relied on this failure to correct these interpersonal relationships as cause for saying, look, this employment relationship can't work going forward. This has been a historic issue, and the employee has never taken it on herself to correct this issue. She's no longer a reasonable employee for us to be required to keep. And so the importance of progressive discipline was really central in this case. It was critical for the employer to show that this was an ongoing issue that had been discussed with the employee and that had not been corrected. But the problem that the employer had is that the people who had issued all of the prior discipline and the prior coaching, they weren't available to testify. And the reasons don't really go into why they weren't available to testify, but in any event, the employer could not produce did not produce anyone to speak to what exactly had happened in the previous discipline, to sort of endorse the record of discipline, if you will. So there was no way for the employer to ground the records in a witness. And so what the employer does, rather ingeniously, is they try to have the records admitted as business records. Say, look, this HR person made these records and part of their function in the organization, and this was part of the ordinary course of business. So you should admit these records as business records, and we shouldn't have to provide anyone to actually speak to this question of prior discipline. So, unfortunately for the employer, the board found that the business records exception does not apply. The disciplinary records specifically don't form part of the day-to-day records of a corporation. And the board said, the sort of records we're looking at are like banking records, nursing charts, these things that are produced almost as an afterthought, right? Really a chronicle rather than a specific incident report. That it's not like you're drafting disciplinary reports on a day-to-day basis. They're kind of exceptional, so it doesn't really fall within that exception. And the board has a little more jurisdiction than a court does in terms of accepting evidence. So they say, well, we'll look at the documents, but we're not going to give them the same weight. And that was really problematic for the employer's case because this was the evidence upon which their case relied. And ultimately, this determination ended up resulting in a decision for the employee because the board basically said, look, we don't have enough in front of us to tell us that this is really that bad of a situation. Problematic, perhaps, but just cause for termination, we don't think so. So that's a case where this business records exception really could have weighted the scales and justified a termination. But instead, because of the less weight put on it, because it wasn't a business record, it really hurt the employer's case. Now, it's possible that case that's certainly a case that is troublesome for employers. There is at least one decision out of Ontario which suggests that there may be a slightly broader interpretation of business records. And that's an arbitration case from 2012 involving the Toronto Community Housing Corporation. Briefly, this was a case in which an individual was disciplined, actually terminated for fraudulently accessing WSIB benefits. And so a big part of this case was the question of what did this individual actually say to the investigators from the WSIB. The problem is that by statute, an individual who is working at the WSIB can't be called to testify. They're not a competent witness. And so the employer had to find some different way of showing what the content was of the representations that the individual made to the WSIB. And they ultimately managed to convince the arbitrator to admit the records that were created in the course of the WSIB investigation and adjudication process on the basis that the WSIB is a business and these records are the normal recordings that are made in the course of that business. So that creates that level of reliability that the arbitrator was looking for in order to rely on these documents. Now, that being said, despite the fact that that was obviously a win for the employer, the arbitrator didn't go so far as to allow the admission of the WSIB caseworkers' actual physical notes that they took of these conversations, because again, those aren't notes that are created in sort of the ordinary course of business. So we still have this problem of how do we make sure that these records are in the normal course of business. So what can we conclude from this? What are some good practices we can draw from this? Well, first of all, we want to find ways to preserve institutional knowledge of past discipline so that it can be relied upon in the future, right? Having a second person witness the record keeping of a discipline, even if it's just a sign off by a superior, that might be that will be helpful in terms of having another person around who can identify the document down the line. You can really try to streamline or homogenize your discipline process, right? Look at creating standard forms that are just fill in the blanks rather than sort of create a loose memo to file system. Because if you have standard forms, then you're more likely to reach that level of reliability that the court is looking for in order to rely on this business records exception. And try to ensure smooth human resources transitions. When somebody resigns, when somebody leaves their position, make sure that their successor is well acquainted with the discipline out there so that they can speak to it and maybe try to avoid some of these problems that you can have in introducing and relying on historic discipline. And so with that, I will hand the mic over to my colleague Amanda Boyce to speak about some recent interesting case law from Alberta.